Hello, everyone. Thank you for joining Meltzer Hellrung's webinar, What the Big Beautiful Bill Means for Employers. We are in Chicago. We're on 12 o'clock Central Time. We are going to give everyone 2 minutes to join the webinar. So we will start formally at 12:02 Central. Thanks for your patience, and we look forward to talking to you shortly. All right. Thank you, everyone who has joined us today. My name is Matt Meltzer. I'm excited to welcome everyone to our webinar today, What the Big Beautiful Bill Means for Employers. A couple of just light housekeeping issues. We are lawyers, but this is not legal advice. Please, 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 if you are an employer or anyone else watching this and you have specific legal questions, please reach out to us or another attorney for advice that is specific to your company. But hopefully this is helpful in giving you a general understanding of the landscape. Second, we are eager and happy to answer questions during the webinar. If you have questions, please put them into the Q&A function. Do not put questions into the webinar chat. Please click on the Q&A to put your questions in. We will do our best to answer questions in real time. If you are not in the webinar anonymously and we do not get to your question during the webinar, we will follow up with you afterwards to answer your question. So rest assured that your questions will be reached. But we also value the questions because they're a great opportunity for us to see what people are thinking about and try to answer those questions and address those issues in the webinar. So with that in mind, let's get started. If you are not a Meltzer Hellrung client already, welcome. If you are a Meltzer Hellrung client, thank you for joining us and taking time to listen to us about the topic today. Just a little bit about us. Meltzer Hellrung, we are a business immigration firm. We combine innovative service and our proprietary technology, Voyager, with our really excellent and creative immigration team. We have well over 200 corporate clients, including Global 200, Fortune 500 companies, as well as venture-backed unicorns. We were recognized as one of the best places to work in Chicago. We were also spotlighted in Chambers for one of the best firms in Illinois for immigration. So we're really excited about the profile we've built over the last decade plus and are really continuing to build and grow. And so thank you for all of the clients who have supported us thus far. A little bit about what service looks like. We have real values and we measure what we are doing. We are responsive. We measure our email response time. We want to answer all emails within 1 business day. We are currently averaging about 4.5 hour business hours to respond to any email that comes into the firm. We are really focused on creating a great experience. And so NPS scores measure what our client satisfaction is. They measure how many people would quote unquote promote your organization. We ask every single foreign national and every client after every single case how they thought the experience went. We have to date in 2025 a 91 NPS score. We had a 92 in 2024. We are efficient. We know how to turn around the cases that need to be turned around fast. For our H-1B transfers, we have our process down pat, and often and should turn around H-1B transfer cases in about 10 business days. And then we value going well beyond just getting a regular case approved. We want to make sure that we are advising clients about how to make immigration effective and efficient, as well as helping them attract and retain the best talent that they seek. And so we have regular touch points. You have the same account team across your cases, and we make sure that we are delving further into what the program looks like to make sure that the immigration strategy suits what your company's needs are. So, who are we? You've been hearing me talk. I'm Matt Meltzer. I'm one of the co-founders and partners here at Meltzer Hellrung. I do a little bit of everything, but in my immigration practice, I often consult with mid-range companies. I also do a lot of work with entrepreneurs and high-skilled individuals. I'm really excited to welcome today my colleague, Michael Taranzik, who is a senior counsel here at the firm. I'll let Mike introduce himself.
Oh yeah, thank you everyone. I'm really pleased that you all are taking time from what is probably for many your lunch break to be with us today. We're going to try to make it as valuable and useful as we can. My name is Michael Taranzik. I'm senior counsel here at Meltzer Hellrung, and I've been practicing immigration law for over 30 years. Like Matt, my background is primarily in business immigration. I have represented companies all the way from startups to Fortune 100 companies and pretty much everything in between, and have always had a particular focus on the immigration compliance side of our practice, having worked with many clients on I-9 audits and having done some policy work in the I-9 area.
Great. One quick piece of information about our technology. You heard me say earlier, we have proprietary technology. This is Voyager, our proprietary platform that allows us to manage immigration cases and the program for our clients. It's just a little bit of an overview of what that platform looks like and sort of like the user interface. We really pride ourselves on having something that's easy to use and intuitive and gives everyone information that they can get without an email at their fingertips, and gives people who are participating in the process really a strong sense of what the narrative of a case will be, where things are, when they will occur. And we have extensive reporting capabilities so that clients can find out things about everything about their account and their cases quickly. So let's come on to talk about what we're doing today. So today we're going to talk largely about compliance and enforcement. We're going to be talking about what the big, beautiful bill means for those things. So we're going to talk about what the state of enforcement has been before the big, beautiful bill, and then what the big, beautiful bill will mean going forward. We'll talk about fines and penalties. Then we're going to really hone in on what you as companies and company representatives can do to mitigate exposure. We'll talk about what real experience of going through an audit looks like. Hopefully, most of you have never experienced that, but let you know what that painful experience is like. Talk a little bit about I-9s, E-Verify, and using those tools on a day-to-day basis. One quick note, the slides and this entire webinar will be available to everyone after the webinar, so you don't have to worry about that. Similarly, if you ever want to see any of our content, it's all available on meltzerhellrung.com. If you go to our resources page, all of our webinars are recorded and you can download them at any given time. All right, Mike, I'll let you get started here.
Okay, sure. So, thank you, Matt. And, as Matt said, I think we want to start off by sort of giving you sort of the state of practice right now, before any of the impact of the reconciliation bill is really felt. So, it's really been no secret that enforcement has increased substantially in the last 6 months. Pretty much right out the door, there were executive orders, defining our immigration system as a national emergency and a crisis. And while the enforcement initially was described as allegedly targeting the worst of the worst, it seemed to rapidly expand and include those that did not have any apparent significant criminal issues or immigration history. So, there are also sanctuary cities have been a big focus. As you can see, there's been a lot of enforcement around sanctuary cities, and in part because the administration seems to equate the sanctuary city programs as a form of obstruction of justice. The border czar Tom Homan pretty much said that to the media a few months ago. There have been other enforcement actions in other cities. Here in Chicago, they were actually detaining folks who were appearing at immigration, individuals trying to comply with their immigration orders. They were taking them into custody when they showed up at immigration. So really, really aggressive enforcement's been going on. It's not just in Chicago. It's been going on in places like San Diego, Colorado Springs, lots of other cities around the country. Despite that, in May, DHS Secretary Kristi Noem and Stephen Miller, who's Deputy Chief of Staff to the President and a longtime proponent of reduced immigration, was really pressuring Immigration and Customs Enforcement to increase their arrests and really targeting 3,000 arrests a day, which is an incredible number. If you do the math, that's 1 million per year. So it's happening. It's increasing, as you can see from the last point there. Year over year, ICE arrests have increased over 268% compared to the same time last year. It's really, I think, clear evidence that this administration is going to be focusing on enforcement, accountability of employers, not as so much concerned about the individuals. They really have not expressed a concern about issues such as family separation, which is happening. It happened under the last Trump administration and is happening now. So I think there's a lot here that's happened already in advance of the big, beautiful bill. So, and here, what we've done here is, here are just some of the headlines that have happened. It's just a small sampling of some of the headlines that have occurred around the country in connection with the recent passage of what really technically is the fiscal year 2025 budget reconciliation bill. It was the president gave it the term "one big beautiful bill" for political reasons. It was passed by the Congress. It was signed by the president on July 4th, and it substantially increases funding for ICE, which is going to have multiple effects. But the one impact that I think that is most relevant for those of us here is that it's going to be creating the potential for significantly more frequent and more extensive investigations of employer I-9 records. And just to put some context around that, in the last year of the Biden administration, there were approximately 300 or so formal I-9 audits, most of which, from my conversations with folks at ICE and HSI, were complaint-driven, were lead-driven. So, they were really focusing on instances where they had specific information that there was illegal activity. Now compare that with the last year of Trump 1.0, in which there were over 6,000 I-9 audits per year. And then compare that again with ICE's stated targets of having over 12,000 audits in the next year. So, that's all pretty impressive. Yeah, to be candid, those numbers are probably not realistic in that the agency is going to be limited by resources, by the number of officers they have, and their ability to complete audits and investigations and take them to a final decision. So I think it's just sort of laying the background here. There's going to be a tremendous potential for an increase, but it's going to happen over time. Maybe switch to the next slide.
Frank,
I'm sorry, go ahead.
What is a complaint? Like, when you say ICE has some sort of complaint-driven process, like where does that information come from?
Oh, it can come from a disgruntled employee, either current or former. It can come from a competitor. It can come from a member of the public. There's a general policy that investigations, all complaints are investigated. Now they're investigated for credibility initially. So if there's just a complaint that has no substance to it, that it will begin and end quickly. But they'll look at the information they receive, and they will take them through the beginning of the investigation process. And if they appear legitimate, then they'll begin the process of doing a formal investigation, getting evidence, possibly in the I-9 context, having an officer pose as a prospective employee, without documents, and see how that person. That happens frequently. That's happened lots of times over the years. So that's what it's going to do. Those will be the primary lead-driven investigation bases.
Yeah, I would just say that in terms of all areas of immigration compliance. Sort of like employee doxing is one of the biggest risks that any employer can face. A lot of times that uh, what your compliant companies that are really strong on compliance, if they're going to get investigated, it's from an employee, and your biggest risk is from disgruntled and former employees who want to uh, exact a little ounce of revenge on their way out. And there's Reddit threads and other places where you can learn about where to file a complaint, and it's a really good way to anonymously get back at your company to make them go through some really painful compliance audits.
One other point I'll just add really quickly before we go on to the next slide is that ICE has been engaging in an increased number of what are referred to as knock and talk um, um, interviews with clients. So they'll just knock on the door without a warrant and just say, can we talk to you about your immigration compliance program? And in that context, they'll ask about the employer. But my understanding is that they will also ask about, okay, so tell me about these companies. You're essentially tell me about your neighbors. So if you're in a manufacturing business and you've got other manufacturing businesses in the locale, there is a question that happens commonly where they will ask you basically to what's the term, drop a dime on your neighbor in terms of immigration compliance. So there are lots of ways they're getting information now that could lead to a future investigation. So I wanted to talk. Yeah, we were talking about government funding, and I just highlighted here almost 30 billion given to ICE for hiring of agents and related infrastructure. Uh, last just a point of reference, last fiscal year 2024, the base appropriation for ICE was approximately 8.7 billion, which covered all operations and enforcement priorities. So this bill has given several times that for much of the same purpose and is targeted to allow the agency to hire up to 10,000 new ICE agents and to cover associated costs. So obviously that's not going to happen at once, and it's not going to happen in this fiscal year. The way the bill was structured, that money can be spent over time so that the agency will be able to ramp up both with hiring as well as infrastructure. But the bottom line of that number is they're going to have a lot more officers, and a lot more officers are going to be devoted to I-9 audit, compliance, and enforcement. All right. So what we thought we would do is not everyone tracks the numbers carefully, but we also wanted you to see the most recent civil penalty grid for the I-9 area. Mm-hmm. These numbers are updated every year, and the latest update was in February 23rd. And as you can see, the numbers are more significant the more egregious the violation. But what I'd like to highlight is even something that's, quote, as simple as a paperwork error can quickly multiply into a significant fine pretty quickly. So for example, take sort of a fairly benign paperwork violation. You have a U.S. employer who may be very well intentioned but not necessarily well trained, that doesn't work in Puerto Rico, but use the Spanish language version of the Form I-9, which is only supposed to be used in Puerto Rico, for several hundred Spanish-speaking employees. That's a technical violation, and as you can see from the chart, the fines are levied per form. So just say for purposes of argument, the fine is issued because the employer is otherwise generally compliant on the low end of the scale, just say $300, but there are 400 I-9s that are defective. I'll do the math for you. It's a $120,000 fine. It's a pretty significant amount. And no one wants to be the HR manager or director who has to go into the owner or the manager of the business and say, hey, can you write 120,000 check because we made a good faith mistake. So it's really important, I think, to focus on the fact that these fines can escalate pretty quickly. In addition to paperwork violations, there could be, document fraud. Accepting fraudulent green cards is, happens, in a lot of the investigation fine proceedings. You see that happening with some frequency, as well as being charged with knowing hire violations. So when you start adding that up, it's not uncommon for employers with significant number of issues with the agency to have six-figure fines. maybe move on, Matt. I only want to highlight this briefly. There are criminal penalties in the statute for noncompliance. So, a pattern or practice, which is to say, you've been found multiple occasions to hire or continue to employ undocumented workers, the employer, not if the HR manager is doing the hiring, that's fine. But if you're the employer, and the HR manager would be charged as well, but the employer who could be far removed from the hiring process would also be subject to some of these criminal penalties. So 6 months in jail, pattern and practice, making false statements, misusing immigration documents, lying to the government is very serious. They take that very seriously, as you can see by the amount of the criminal penalty imposed. And then harboring. Harboring is something that this administration has signaled. I believe it was, again, Tom Homan, as well as the Attorney General's office, U.S. Attorney General's office, is something that they're going to be using more aggressively against employers. In the term of those continuing to employ undocumented workers. So you can see that's a serious criminal penalty with a serious potential prison sentence. And
What? Oh,
go
sorry.
ahead. Yeah.
What constitutes a pattern? Like, is one person a pattern?
Well, typically, if and I don't want to go back to the slide, but if you look at the slide on the fines, it's first violation, second violation, and then third or subsequent events. You're typically going to be in the third or subsequent event before you end up with pattern or practice concerns from the employer's perspective, at least in my experience. I do want to say one more thing about this, just on the harboring issue, and I'm sorry, not on the harboring alone, but on the criminal penalties issues. This is already happening, and there was a highly publicized incident in San Diego just a couple of months ago where investigators came into a very popular restaurant, did a worksite enforcement action, found nearly half of the employees had submitted fraudulent green cards, and that the management knew it and accepted them anyway. And that case is currently in the criminal process. That employer is facing criminal penalties for the actions of his staff. So this is serious stuff. This is happening, and it's expected to continue to expand. So Matt, I think at this point I'm gonna let you take the mic for a few minutes and talk about best practices.
Yeah, absolutely. There's a great question that I think is helpful just to start here. As someone put in, does this all apply to 1099 employees? What about off the books employees like household cleaners? I think it's really important to note that I-9s are for any W-2 employee, or anyone who should be a W-2 employee. So if you are mischaracterizing people as 1099s when they really should be W-2s, you probably face double liability as potentially a DOL error and an I-9 error. And people who you haven't done an I-9 for at all doesn't mean you're off the hook. Just because you did fail to complete an I-9, someone who should be a W-2, including household employees, depending if they qualify, you could be liable for it too. So this can apply to household employers. So let's talk about I-9 best practices. The number one thing is you should have a process. Someone somewhere in the company should own it. It should not be something that is left to individual departments to do as they see fit on the first day. Really, we encourage someone at the company to be in charge of I-9 and implement that systematically across the company. However you do that, we think that having a written policy is really great. It's helpful in terms of getting information to the government as well, should you ever be investigated, and having a training process for people who are administering I-9s. Your weakest link at a company is always at the individual level of who is handling the I-9s. A really great, well-designed program with a great policy can still be bungled by a person who is individually handling the I-9s. So in addition to actually training people, it's really important to make sure that there is some sort of like function to actually investigate, are things being done correctly, especially when you bring new people into the I-9 process. Second, use the most up-to-date version of the I-9. If you use paper I-9s, make sure that you visit the USCIS website semi-frequently to make sure you have the current I-9. USCIS does not release new I-9s that frequently, and they rarely give short notice. Usually they give almost a year of notice of when a new I-9 is going to go into effect because they don't want employers to be caught in a place where they change the I-9 and it goes into effect tomorrow. That's not what the government is trying to do. They're not trying to uh, shake down employers for not knowing that a form changed very quickly on this area. So make sure you have the most up-to-date version. If you use a sophisticated I-9 software, it is almost for sure that your software provider is providing you the most current form of I-9. But just to know that using a sophisticated software does not get you off the hook if you're using the wrong version. It's still the employer's responsibility to make sure that there is the correct version because if the wrong form is in the I-9 provider, you're still going to be on the hook regardless of whether or not you said that you're using a provider that has an electronic system. Have your I-9s centralized. That means have them all in one place. And this is really important for an audit purpose. If you are subject to an audit, the government will give you 3 days to get all of your I-9s to the government. And they can ask for them all in paper, even if you have them stored electronically. So if you do not have them all in a centralized place, your likelihood of just complying with that first request of getting your I-9s to the government in 3 days is almost certain to fail. So get them centralized, know where they are. That is the best for having access to them to doing a kind of self-audit and review, but also for actual government compliance should you ever be investigated. Conduct spot audits. We're going to talk more about spot audits. We'll talk much more about how you can review your I-9s to check that you're doing things well, make sure your policies are being enacted correctly to make sure that there aren't any issues here, and to correct errors as they arise. But conducting a spot audit is the first, after having a policy, is really the best way to make sure that you're compliant. And then purging I-9s. You are able to remove I-9s for employees who are terminated. We'll talk more about like when that is, but you can't be fined for an I-9 that you have appropriately taken out of your system. However, if you have an employee who left 7 years ago and you've left that I-9 in your files and you get an audit and it's wrong, you can still be fined for that I-9. So the best way to make sure that you're minimizing any liability is removing I-9s from your files that you can. And that can be part of your spot audit. Like there can either be part of your policy about how to remove terminated employees and their I-9s, or it can be part of your auditing process. And then if you are using a software, we really encourage you to be very careful and thoughtful about how you go and use the software. Like it is important to assess who that software vendor is, what is their sophistication, how long have they been in the software of I-9 business? Can they talk about who any of their other kind of clients are? I would be really wary of using someone who started yesterday. Someone who's been in this industry for 15 or 20 years is highly likely to be really strong. Someone who has other strong HRIS tools, but maybe is new to this, probably is also likely to have a strong process for making sure they're compliant if they're strong in other compliance areas. But really important to make sure you're not just choosing the cheapest software and then going with that.
Yeah, let me just add a quick point on that, Matt. I think one of the issues that we've seen, and when I say we, I see the immigration bar has seen with I-9 software systems, is that some systems are really built to be I-9 compliant, and some systems are built as an adjunct to a larger HRIS system. They all have their pros and cons, and certainly there's some economies involved in the latter. But I think it's really important if you're using one of those systems that's associated with an HRIS system to make sure that their audit trail is compliant. And by that I mean, does the system carefully and meticulously track when I-9s are edited, who did it, when they did it, and what they did? We have seen circumstances in the recent past, within the last few years, where clients have been fined six-figure amounts for inadequacies of an otherwise very well defined, designed I-9 software system. So I think that's always a question you have to look at the forefront. Does the audit trail allow the government in an investigation to come into the system and see what was done, when it was done, and who did it? Now, there was a question, Matt, I think in the Q&A about what we mean by a written policy. And maybe I'll just start off with my perspective on it and you can add on, which is I think it's important to have a written policy for a bunch of reasons. One, training, consistency of process, but also it's a document. It's evidence that can be used to show in a fine negotiation that you're a serious employer, that you've got a process. Here's my process, Mr. Investigator or Ms. Investigator. Here's what we do. Here's how we're supposed to do it. And this is what we consider our benchmark, our bedrock document for completing the I-9 process. So I think those are the two reasons why you want to have a written policy. One, because it aids, when you're training and adding staff to your I-9 team, but also it provides evidence, that you take this stuff seriously.
Is there a size of employer that you recommend? That's like, does a company that has 10 employees, should they prioritize creating an I-9 policy document? Is there a sort of like any kind of tipping point where you think it's really important to implement?
I would key it more towards hiring frequency. So
Okay.
yeah, I mean, I think there's a risk versus cost. Now, if the risk is lower than the cost of doing that and maintaining the policy, then maybe you have to have a conversation with the employer. But it's generally good to have an I-9 policy, even if it's a short one, right? It can be a page or two. But your question is a good one in that not every employer is going to have the hiring frequency where they need to have an official policy. Flip side of that is if you don't hire frequency, my experience has been when the I-9 comes out, it's not always handled well.
Yeah. And again, I think that's a really good point, Mike. Policy could be a lengthy, really process. A policy could also be simple as the HR manager, or if you're even smaller company that doesn't have an HR, the CFO or whoever it might be is responsible for handling I-9s in the first 3 business days of the employee's new employment. That I-9 will be stored in the following location subsequently, and that could be a policy like that. It doesn't have to be a long thing just to get you started of saying who is responsible and where it's going to be kept. Mike, the other thing I see a lot of questions about coming in about termination of like what does it mean for a terminated employee and how do you purge an I-9 for someone who has left the company, whether voluntarily or involuntarily?
Well, well, first of all, when employment ends and you are, for lack of a better term, offboarding someone, the I-9 has to be part of that procedure. And what I've generally recommended over the years is at that point in time, you pull the I-9 and do a calculation of what would be the date of destruction, the date you can purge the I-9. And the general rule is 3 years from the date of hire or 1 year from the date of termination, whichever is later, right? It's not a hard calculation. You put the date of hire, you put the date of termination. You can really just write them on. I've had clients just write them on the top of the I-9 when they've done paper I-9s, and then the date of destruction, which is the third date, calculated based on that formula. And I've seen employers get this wrong, but not so much in recent past. I had an employer a long time ago where the employee didn't get it right. The HR manager for immigration did not get it right. And the employer literally had to recreate thousands of I-9s that were wrongfully terminated. So it's important to get that right. It's important to make sure that it's monitored and that you have a system. And I've recommended just a monthly purge so that it's not labor and time intensive. You just every month you look into your system and figure out which I-9s can be terminated that month and you deal with it.
And Mike, that is a common question that's coming in about do you use E-Verify too? Do you purge E-Verify?
No, no.
Okay.
E-Verify and the I-9 process are separate. Understand the I-9 process is the employer's responsibility. E-Verify is a service that the government provides that enables you through checking data, Social Security, and through DHS to confirm employment authorization. So the whatever you're doing with I-9s in the context of retention is separate from that.
All right. So let's talk about what kind of issues often come up in an audit. Uh, what are the issues that that we see most often? Like the number of things that happen are prevalent. We see employers make all kinds of errors frequently. Uh, Oftentimes it's a training problem or an employee not understanding how the process works problem. But you have to make sure that that training is occurring with the people who are handling your I-9s. And if you as a company don't feel competent at training new employees on how to handle I-9s, find a vendor, like whether that's us or someone else. There are plenty of law firms and companies that are happy to help train on compliant I-9. But in terms of like what it's going to take to do it consistent with the policy internally, that's something you still need a written policy on making sure where are these documents going to be saved and kept. Um, Accepting unacceptable documents. That's a big one. If the standard here is fraud. The employers are not responsible for determining whether any document is truly accurate. That is partly E-Verify's work to do if you use E-Verify. But if something looks clearly manufactured, like you get a green card and there's no hologram on it, uh, you're looking at a social security card that looks like it's a misprint. Like you're probably not going to withstand scrutiny.
Yeah, and I'm just mad. In my recent experience, I saw one that was valid for 18 years. So that's a red flag. Because
So
actually, just everybody knows, green cards are usually issued for 2 years or 10 years. When you see something that's 18 years, there's usually, if you know a little bit about this, there's a duty to inquire further. Yeah.
um,
Hmm.
not recording correctly what the titles and the authorities are of the documents. So in the I-9, you need to say what documents you actually looked at, whether or not you're saving a copy. You need to say what you looked at. So if you don't record what you actually looked at with issuing authorities and expiration dates, you're going to have a problem. If you are doing I-9 audits, if you are not showing what the corrections were and properly detailing how those corrections were made, you can get in trouble. And so that goes to a question of like self-audit we'll talk about more. But if you're doing a self-audit, you can make corrections on your I-9. If you see an error, like for example, if you go through an I-9 and you see that there was no issuing authority on a document, you say, oh, this person used a passport, but we didn't write passport down. Well, you can make sure that you get the issuing authority correct on that and correct it, but you should note when that correction was made. You should next to that, you should sign initial and date when that correction was made, or provide a supporting page after the I-9 to detail what that change was. The biggest thing is not conducting any kind of auditing. You don't know what problems you have until you audit. And we do not think that you have to audit everything every year. Like for larger employers with hiring frequently, we'll talk more about spot auditing, but this does not have to be a painful process. Our best clients engage in some kind of self-audit every 6 or 12 months. You do not need to audit everything. You can audit a selection. If you take 10%, 5% of things that are new and everything looks clean and is beautiful, probably not a lot of reason to continue auditing things. If you take 10% and 20% of those things have errors, that's probably a reason to keep going and auditing further. So there is a time, and risk management here that you can choose how much you're auditing and engaging with your own materials. But even just documenting when those audits occurred, what happened will give you a lot of credibility with the government. Mike, anything else here in terms of the common audit issues that you want to address in terms of like what employers should be thinking about?
I think this covers really all of the basics. I think these are the common issues that I've seen and many others have seen over time. But I also think it's important for, you know, CHRO, you know, senior HR folks to be involved in this now. The risks are increasing. I would say, in general, in the immigration field, it's important to have the C-suite involved more in the immigration, but also when there are definite compliance issues. I think it's where there's compliance exposure, it would be important to have them involved. And that's my one comment. Yeah. All right. There we go.
Right.
So I'm just gonna. I mean, I'm happy to do that, Matt. If you
Yeah, go
want,
for it.
yeah, I'll give you a break from talking. So what we've done here is outline. We're going to try to do this in 2 minutes because I see we're getting towards the end of a lot of time. But there are several different outcomes of an I-9 investigation. One of them is when the government finds substantial violations. And well, it's actually, let me start. It starts with a notice of inspection. ICE will deliver a notice to you, and as we said, you'll have 3 days at a minimum to respond. Often we can negotiate a longer period of time. It involves a conversation directly with the investigator. Whatever period is given, the employer is required to provide all the I-9 forms requested in the audit notice and any requested supporting documentation. There can be payroll records. There can be other information associated with the I-9s that's requested. So we work with the employer and the government to get an acceptable process time and acceptable documents, submit them over to ICE for review, and then, basically we don't know how long it's going to take. It depends upon the priorities of the office, the workload of the officer, but eventually you'll receive an ICE notification of results, which, as you can see there in the small print, sorry for that, but there are several outcomes. Compliance letter is the best thing. The government finds you're generally compliant. A notice of suspect documents or discrepancy indicates that the review of the employee's information has identified some irregularities that require further examination or rectification by the employee. A notice of technical and procedural failures is really focused at the employer, saying we found the following problems. You have 30 days or whatever period to correct them. A warning notice is generally not bad news. It says we've identified the following violations, but we're letting you off with a warning this time. So there'll be no fines involved. And then lastly, there's the notice of intent to fine, which indicates that the agency has found the following violations. And here, based upon that fine matrix that I discussed earlier, here's the fine that we're going to issue. So, as I said, in some of the scenarios, you have the opportunity to address the deficiencies. In a notice of inspection scenario, you will have 30 days to request a hearing before the Office of the Chief Administrative Hearing Officer, also known as OCAHO, which is the quasi-judicial body that is responsible for reviewing audit fine determinations. Now, during this period, typically, what I would say is, I call up the investigator and, my client, is really uncomfortable with the fine amount. We don't think that it's fair for the following reasons. And, we're going to have to appeal this unless we can come to some accommodation or some discussion about this. And you have a negotiation, and the ICE officers who do this every day, right? They're doing this on a regular basis. We'll have a conversation and decide what's reasonable. Caveat here, under this administration, they may be somewhat constrained in their ability and their flexibility to negotiate fines, but you still want to have that conversation negotiation before you head off to OCAHO. If you go to OCAHO, as I said, it's really like going to federal court. There's discovery practice where you get information from the government about their audit. You can file motions in terms of evidentiary issues. There'll be a pre-trial conference with the judge. So it'll follow that regular track, and then you'll get a decision, which at that point will go to a real legislative judge in federal court. So, Matt,
Mike, do you want? I know it's getting deep into the weeds here, but
yeah.
What happens if, is there a reason for an employer who gets a really big fine if you're getting one of those six-figure fines or assess liability for one of those six-figure fines to think about challenging Okaho?
Well, yeah, I mean, I think that it's that my initial reaction is yes, if it's fact or law driven, right? So if you look at forget six figures, I think you know SpaceX had a 7 or 8 figure fine. Walmart had a 7 or 8 figure fine. They appealed those to Okaho, and they went to federal court. And those cases, there were injunctions issues. We don't have time to discuss those right now. But if there is a reasonable basis for you to argue that the fine is improper, I would definitely consider appealing to Okaho. They are, as I said, quasi judicial, quasi independent agency here that doesn't that doesn't work with ICE or work for or in association with DHS. They're independent, so they will hear it, impartially. So I don't know if that answers your question, but I tend to defer to the facts and whether there was a misapplication of law.
All right, let's go over just quickly for we're working sort of backwards here. But what is a who must complete an I-9? As we talked about before, all employees, any W-2 employee working in the US must have Form I-9. Does not matter whether they work 2 hours a week or work 40 hours a week. Anyone who's a W-2 needs an I-9. You need an I-9 for people working in your office. You need an I-9 for people who are working remotely from any location in the US. You should not complete I-9s for properly classified 1099s. You should not complete I-9s for people who are not working for you directly. So if you have staff from any kind of staffing agency, those are not your employees, they're the agency's employees. You should not do I-9s for unpaid interns. You do not need an I-9 even if someone is an employee or you're treating as an employee who is not working in the US. So if you have someone who's working for you from Canada, Mexico, Iceland, uh, wherever you do not need an I-9, you should not do one. And you also don't need one for private home casual domestic workers who work on a sporadic intermittent basis. So if you have a full-time nanny, that person needs an I-9. If you have a housekeeper who shows up 1 hour a week, that person does not. Basics of I-9s. I-9 must occur after the offer acceptance and no later than the first day of employment for Section 1 of Form I-9. So that means that you can do an I-9 before a person starts. If you make an offer today and someone starts 2 weeks from today, you can do Section 1 of the I-9 anytime between now and that first date. You don't need to wait for the first date for the person to do an I-9. Step 2, within 3 business days of the first day of employment, the employee must present acceptable documents showing work authorization under the list A, B, or C documents, proving identity and work authorization. Definitely the most complicated part of the I-9 is those documents. For a US citizen presenting a passport, great, that's super easy. For lots of individuals who have other kinds of work authorization, it can get challenging. There is a multiple 100-page document called the M274 that advises employers on how to do this and what documents to look for. You as an employer can never request specific documents. You can tell people that they don't have what they need and need to come back, but you cannot request specific documents. That is potential nationality and immigration discrimination. So do not request specific documents from employees. And then within 3 business days of the first day of employment, the employer must inspect in person the original documents. Then the employer must complete Section 2 of the I-9. You need to remember that if these documents expire for a non-US citizen and non-permanent resident, you need to re-verify I-9. One thing you can get in trouble for on I-9 audits is re-verifying things that shouldn't have been re-verified. So if someone comes to you and they have a green card and it expires in 5 years, and you re-verify someone in 5 years, that's also actionable. You should not re-verify things that don't need to be re-verified. Mike, anything on the basics of Form I-9 completion that you want to go over?
Not now. I'm just keeping an eye on the clock here, so I want to make sure we try to
All right.
remotely stay on stay on agenda. Yeah.
Retention. Keep your I-9s for the duration of the employment. You can store them digitally, physically. You need to, if you have physical forms, you need to keep the physical forms so they are available, but you can keep a digital copy too. If they're only digital, you don't need to print them out. Upon termination, you can and should purge them, as we talked about before. Um, you can, Mike, do you need to keep copies of your I-9 supporting documents, the list A, B, and C documents? If someone presents a passport, do you need to keep a copy of the passport?
You need to keep a copy of the documentation. Well, I should say, step back. Um, if you are using e-verify, you need to keep copies, right? If you're not using e-verify, it's optional but recommended. And my policy has always been you keep the documentation used to satisfy the I-9 requirements. You don't keep extraneous documents. So if a passport was used, U.S. passport was used, then keeping a copy of the U.S. passport makes perfect sense. If you do the I-9 audit, you see a passport, a social security card, some other ID, a W-2 or something. You see all that in there. It just creates a perception that there might be over documentation, document abuse, which is a separate finable offense.
Then also within termination, employers may purge a terminated employee's Form I-9 digitally or manually, depending on what's there, 3 years from the date of employment or 1 year from the date of termination. You need an internal process for this. Employers should purge eligible Form I-9 employee files on an annual basis at a minimum. Um, Again, this really is going to depend on the size of your company in terms of like what the pain point is here. If you have multiple thousands of employees, you probably want to make this a monthly or even weekly process. If you have 100 employees, annuals certainly going to be sufficient. Um, and then you should do spot audits to ensure that you're adhering to your procedures. And I think spot audits are really important so that anyone new takes on an I-9 task. You have anyone new touching I-9s, I think spot audits become even more important. I would encourage you to do them, conduct them more recently when someone starts working on I-9s. And again, a spot audit is not to look at every single I-9. It is to look at some portion, and you can choose any number of ways. You could choose based on last name letters. You could choose based on social security numbers, odds and evens. You could just choose dates of start of work. Just choose something that gives you some sort of randomness of like what is looking at, and then look at your I-9s carefully to ensure they're compliant. Mike,
Oh,
what's being you want to talk about anything else in terms of the I-9
yeah. No,
retention?
I'm just getting out of the Q&A. I'm sorry. No, let's go on. I think we've got 7 or 8 minutes left, so I want to try to maybe even leave a minute or two to get to some of the questions. So we talked in the invitation about proposals currently working their way through Congress to make e-verify mandatory and to modernize some of the requirements. There was a bill that was introduced this month called the Dignity Act of 2025, a bipartisan bill, incredibly bipartisan bill with 22 co-sponsors, 11 Democrats and 11 Republicans, that would make e-verify mandatory for all employers in the United States during a phased-in implementation period. And quite simply, it would say it would go by size of employer. So the largest employers would have to be using e-verify within 6 months, and then it would just cascade down to employers of 1 to 20 employees having fully 2 years to convert to e-verify. The agriculture industry, which will struggle with this and has been a loud and constant voice against mandating e-verify for reasons that are probably obvious to all of us, would get a 30-month phase-in period. It would, on a modernization perspective, it's accelerating the movement towards a paperless employment verification process, taking what is currently sort of e-verify, and as I said earlier, e-verify is adjunct to the I-9 process, but not the same as the I-9. It would really sort of combine the two processes for a purely electronic employment verification process, which could be a real good thing for employers because it might remove us even further, us employers, from the obligation to verify employment compliance. Um, it would also have, in addition to some of these more positive, it would have additional criminal penalties. So we're looking at a bill that would, really uptick some of those civil and criminal penalties that I've described earlier. Now, question many have been asking, well, it's only legislation, it's only proposed. I will say, yes, the bill has many other aspects to it. Some I think we would generally agree with, some we may have questions about. It is a serious attempt to make significant reforms to our immigration law. E-Verify is just one component of it. I think one aspect, and I've commented on this in other venues, is that right now, one of the biggest challenges, one of the historically biggest challenges to getting immigration passed was this concern that the border was out of control. Well, right now, it's hard to make that argument given all the enforcement that's happening and the decreased number of apprehensions at the border that have been happening over the last 6 months. So there could be a window of opportunity for this piece of legislation to move. It was introduced in 2023, never went anywhere for probably more political reasons than anything else. But I think it's a bill that bears watching. I think maybe we should move on.
Right.
Yeah.
Absolutely.
Yeah.
What is E-Verify? Well, I'll take this one.
Okay.
E-Verify is it's a free federal system that will actually check the document. So I-9s are just a form you need to keep for any hire. E-Verify is a supplemental system. It is something that checks the validity of the documents being presented. In some states, E-Verify is mandatory. For federal contracting companies, E-Verify is mandatory. Um, if you are hiring STEM OPT employees, E-Verify is mandatory. For other employers, E-Verify is voluntary. There are pros and cons of using E-Verify. The plus is that it limits your likelihood of being audited because you're more likely to be compliant with I-9s and less likely to be hiring unauthorized workers. It gives also a whole lot more information to the government for them to be able to track and check on, and if you're doing things that look weird, might maybe trigger an audit. We're not sure how AI will play into what E-Verify data is used for going forward. But once you enroll in E-Verify, you must use it for everyone. So if you decide that you have first time you're hiring a STEM OPT employee, you want to add on E-Verify, it is not for that one employee. It is for every future hire. There is no cost to using E-Verify. It is totally free, but it does add additional compliance steps to your workflow. E-Verify Plus. This is a new tool. It is honestly, in my mind, pretty cool. E-Verify Plus allows E-Verify and I-9s to work together. So it does two things. On the employer side, it will, when you use this E-Verify Plus, it will generate a Form I-9 for you out of your E-Verify process. So it means that you will have, it seems almost impossible to be non-compliant on your I-9s because the US government is creating your I-9 for you. So that's a huge plus. The other thing is that it allows employees to be stored in the government system so that if someone is a US citizen and they've gone through an E-Verify Plus process with one company, they are now in the E-Verify Plus system. And when they bring their work authorization to employer number two, they will already be in the system and work verified. You don't really need to do much to verify it. So it creates an easier process from an employee perspective, especially someone who might be changing jobs frequently, depending on their industry. So there are, some major benefits to the system. I think that, it's very new. It's less than a year and a half old. It is something that I don't think many employers who are really large have tried to introduce at any kind of scale. But especially for smaller employers, I think it's a system really worth investigating and deciding to choose. If you're already inclined to use a digital system for your I-9s, I would consider using E-Verify. It saves you a little bit of money because you won't be paying someone else, and I think creates a reduction of liability. Mike, what about you? Any perspective on the E-Verify Plus
Yeah,
system?
I mean, the agency USCIS called, originally called this, E-Verify Next Gen, and it's their effort to make the system more accessible and user friendly. First and foremost, by shifting a lot of the responsibility back on the employee. So the employee will, complete the, complete. They'll get an email from E-Verify Plus. They'll complete section 1 of the form. They'll upload their documentation for section 2, and then the I-9 will essentially be populated, and then the employee will come in if they're doing it in person and have the original documents for examination, and off you go. The I-9 is done. You're compliant. It's in the system. But they will be, in addition to checking the employment authorization documentation, they will also, facilitate the issuance in preparation of the I-9. Now, the employer will still have to download the I-9 and the supporting documentation, keep it for their own records, but E-Verify will alleviate a lot of the burden that the E-Verify Plus will alleviate some of the traditional burdens of E-Verify, in that the TCN, the tentative non-confirmation process, is now going to be on the employee rather than the employer. So the employee will be getting notice of any TCNs and have to deal with it, and then upload or correct the information in E-Verify Plus so that the employer can complete the I-9 process. It really is designed, I think, to bring I-9 processing more in line with what was originally intended when the law was passed way back in 1986. This was never meant to be as burdensome as it has become on employers, and I think this is a small but significant step in the direction of creating paperless I-9s, that where the burden is shifted really more towards the employee and the government than the employer.
Um, Mike, I know we're at time. I just wanted to take a moment to say thank you to everyone who attended. The slides and the webinar will be available. They will be shared. It will also be available on our website. We did not answer all the questions in the Q&A. We will do our best, if you are not anonymous, to reach out to you and try to answer your question if we can. I think for us, the biggest purpose of this webinar was to get people aware that compliance will be increasing. Compliance checks are likely to increase. They're not increasing tomorrow. You have time to get your house in order. Now is the time to do it. If you do not have an attorney who you're working with, we think it makes sense to consider working with one. Get a policy. Make sure you have this stuff documented. Get an audit process. It's worth documenting. And if you are, if you are subject to an investigation, again, you have 3 days to share all those I-9s. You'll never do an audit in those 3 days. It is make sure that you have done a process, make sure you have someone you can call because you want counsel with you for an I-9 audit. It's better to have worked with someone in advance to talk about what your policy and your practice is than to be caught in an audit and have never talked to an attorney before. There's going to be a limit to any attorney's capability to advise you in that process if they have never talked to you about what your I-9 process looks like. So whether that's us or someone else, we really encourage you to think about engaging counsel in your I-9 work, and we look forward to talking to many of you in the future. Feel free to reach out to me, Matt Hellrung, who is not here. His email, Michael, is on the website, but his email is mtaranzik@meltzerhellrung.com. You can also just put in an inquiry on our website on the Contact Us page, and we'll be sure to be able to reach out to you. Thank you very much.
Yes, thanks everyone.